Good day, and welcome to another episode of Q&A Social Security Disability Today. I am your host, Attorney Anthony Reeves, and I thank you for joining me today. For questions and answers, as always, you can just leave your comments here. I encourage everyone to subscribe so you can be alerted when a video has been posted that has answered your question. If your question wasn't answered, or if you want a special video to handle a single topic, please feel free to send me a message in my inbox. And for those of you who are looking at me going, what you reading? I'm reading this so it don't sound crazy. In addition, topics can be found on my blog at legalbeat.anthonyreeves.com. Make sure you subscribe so you can be kept up to date on all topics. If you have Facebook, you can always go to facebook.com/Reeves Law Firm. If you got Twitter, it's Legal Gold. If you can also find me on my social media site, which is anthonyreeves.com. And as always, the show is sponsored by Reeves Law Firm by www.reevesfirm.com. All right. With that, let's get cracking and get on to your questions. Question number one is a workers' compensation question. How can an Utica Mohawk Clause help me with keeping more of my disability? I was disabled under Longshoreman and Harbor's Workers' Compensation Act. Here's one thing most people fail to realize. It doesn't matter whether it's longshoremen, whether it's the Utica, whether it's the Harbor Workers Act and so forth, is that Social Security does a breakdown in terms of what we call workers' compensation offset. So really the question that was asked to me, and thank you gentlemen for your question, was how is this workers' comp offset applicable to my Social Security disability? Well, first of all, let me kind of tell you this. For those of you who don't know what this clause is, it's a clause of a contract which is generally used to explain how a settlement is to be paid out. On the state level, in Florida, it's referred to as a washout agreement. And what it does is it gives a breakdown of how the money is going to be paid over a long period of time. Now, in this instance, it's a little different because what it does, as opposed to giving a breakdown in terms of one lump sum, the payment is broken down so that how much money is going to be paid periodically, such as weekly or monthly. Two things you need to know is that breakdown is going to be relied upon by Social Security to determine how much of an offset it's going to be. Every state is a little different. The governments use it a little differently. But here's what you need to know. And I don't want you to think that I'm not answering your question, but this is what I want you to do. Go to my March 31st, 2011 show. That was a special show that I spent about a good 15, I think like 17 minutes going solely over workers' compensation and offset. I have several questions today on other things, and anytime workers' comp comes up, I direct people to that show because I spent the entire time explaining workers' comp offset. So the reason why I say that is because I don't want you to think that that clause makes it that there's something special that relates to workers' comp as it relates to that clause. At the end of the day, it's all of workers' compensation and how that offset is applied to Social Security. It's a standard formula that they use. So if you go to that show, March 31st, 2011, that'll give you information as to how that offset actually applies. And let me know if that answers your questions. If it doesn't, come on back and I'll be more than happy to clarify. All right. Second question is, does Social Security have to take in consideration that my current and new treating doctor is supporting me that I'm disabled? Will this weigh heavily on their final decision, do you think? Good question. Because you actually have two things, and I've actually brought this up before, but we're going to bring it as a rehash again today. There's a rule that Social Security follows, which is called the treating doctor's rule. And here's what you got to understand. The treating doctor's rule basically says two things. One, if the weight of the medical evidence supports the treating doctor's opinion, then that doctor's opinion should be given substantial weight. In other words, if everybody is saying A, B, C, and D, and your treating doctor is saying A, B, C, and D, then because of the virtue that one, they've known you the longest, they've treated you for the longest, and they have the most intimate knowledge on your care, their weight should be given additional weight because all the other evidence supports it. So let's give an example. Let's say that you say your back is off the chain. It really, really hurts. And you've had to go to the ER for emergency room visits for your back. That's one. Your primary doctor is basically saying that you've got bad back, and they referred you to a neurologist. The neurologist has done an MRI. The MRI reveals that you've got impingements or bulging disc or degenerative joint disease and so forth on your back. And then you've got a neurologist or a pain management doctor that's saying this person's back is really bad. Well, the fact that you've gone to a primary, a neurologist, an MRI, an ER, all of those different things will be evidence that will be used to support the fact that guess what? Your doctor says you have a bad back. All of those evidence is going to be used to give that doctor's weight more weight. Now, the other thing is this: if the weight of the evidence is to the contrary, then the treating doctor's weight will not be given substantial weight. It'll be given some weight, but it won't be given as much weight as it would have had the other doctors substantiated. Here's an example. Let's say your primary doctor says that your back is, oh, it's so bad, it's debilitating. But you go to the ER, they give you over-the-counter medication. They give you some Advil, say go home. They refer you to pain management. Pain management says your back's not that bad. You go to a neurologist. Your neurologist says your back is not that bad. If all of these doctors are saying, and the medical evidence says your back is not that bad, and only one doctor, your primary, says that your back is bad, guess what? Your doctor's opinion, who's saying your back is bad, is not going to be given as much weight because there's a lot of other evidence that says to the contrary. So I hope that makes a little bit more sense. Also, my examiner, third question, my examiner will be forwarding all medical records to the doctor's review. What are my chances of approval? Here's the one thing I tell people all the time. Two things. It's the weight of the medical evidence. They got to look at it all. And secondly, unless you have it all in front of you, there's no way to know the answer to that question. Most people think just because one doctor says that you're off the chain, that they're in there, that you've won, you've made it to the touchdown. But I always tell people, usually at the lower office level and even up to the hearing level, if you haven't seen everything that Social Security has, there's no way to have a definitive idea of the strength of your case. Some things are a little bit stronger than others. A lot of times people with certain diagnoses may have a greater strength to them, but the reality is that there's no way of knowing because it depends on what the medical evidence has. Now, someone says, I was told that if DDS determines that you are disabled, they will not establish your onset date earlier than the date of the ALJ denial. Can DDS really go back to the first claim then without stepping on the ALJ toes, sort of speaking? Here's what you need to understand. Under the regulations, there's a phrase that we call, it's a legal phrase called res judicata. It's basically talking about things that, it's a legal concept that talks about things that have already been judged upon. So when a judge has made a decision, let's say that January 1, 2011, the judge made a decision that you were disabled. Under the rules, the judge technically had the ability to see everything from January 1 going backwards. So if you file a new application on January 2, 2011, Social Security is not going to look back before the date of that January 1 judge's decision because it's presumed that he or she had the benefit of everything going backwards. So they're not going to look at anything before that date. But I'm glad that person brought this question up because it actually brings me to a new topic that you need to be aware of. And it's my last question today, and hopefully I'll be able to get it knocked out in the next 5. If you don't understand and you have more questions, please ask me. Understanding the new rule of Social Security Ruling 11-1P, new Social Security rule changing subsequent application policies. Let me kind of give you a little backdrop to this. On July 28th, there was a rule of 2011, there was a new rule issued, a rule 11-1P. Before that ruling, what would happen is that if you went to a hearing and you got denied, well, a lot of practitioners, and I was one who would do it as well, what we would do is if we felt that you were disabled, we would encourage you to, one, file the appeal so that you could go after your retroactive benefits from the date of the judge's decision going backwards, and file a new application if you still believe that your condition kept you from being able to work. What that did is it gave you the benefit of having 2 applications going at the same time. Your old one would still be reviewed by the Social Security Administration at the Appeals Council, and your new one would go to the local office. Social Security has basically cut that at the passes as of right now. So what happens is this. When you get denied at the judge's level, you have a choice. And here's the choice. You either can appeal your case or you can go forward with a new application. Well, you ask yourself, well, wait a minute. Are you saying I can't do both? That's exactly what I'm saying. You can't do both. Now, they're still trying to work this out, so there's going to be some new details, but let me kind of see if I can break it down. And if you have more questions, let me know. This is still new, so There may be some quirks in here and there. Here's how it plays out. If you are at a point where the judges found that you are not disabled, but you still feel you are disabled, you have a choice. You can either appeal your case and let an appeals counsel review your medical records, or you can file a new application. You can't do both. Well, what happens if I just file an appeal? Well, then what happens is that it goes to the appeals council and they will continue to review. You can't file a new application while it's pending. Now, for those of you, I'm going to tell you this right now. If you have a representative, make sure you sit down and get a complete understanding of what it means if you do not file a new application or if you appeal. Because if you have what we call DLI issue, date last insured issues that have popped up in there, there may be a potential issue with your case. So make sure you speak to your representative and appreciate what your decision will mean. If you file a new application, if you file a case with the appeals council, Social Security will not take that new application unless it is for an application for something totally different than what you did before. Meaning, let's say your spouse died, so you're trying to apply under the disabled widow's benefits. They made under that situation. Let's say you had a Title II claim, and then possibly now you're going for SSI. They may take it. But under most circumstances, if you're trying to say, I disagree, I'm still disabled under the same things, and you have no new evidence and nothing has really changed, they're not going to take your new application unless you agree to withdraw your appeal to the appeals council. If you withdraw your appeal to the appeals council, your ability to go for your back pay is done. Keep that in mind. It's a wrap. Now, are there other instances that come into play? Well, if there's new evidence that comes up, let's say, for instance, that you say you have a bad back. Okay? Let's say you have a bad back. And all of a sudden, you get denied on January 1, 2011. And the judge says no. So you appeal to the appeals council. So now you go to file a new application because on January 2, you were in a nasty car accident. So guess what? Your back is not like it was before. What happens is that Social Security technically has to contact the appeals council to determine whether or not you can be permitted to do a new application, because you're now saying, well, I'm not alleging disability on my old application. I'm going on the date of January 2nd, 2011 when I had the accident. So under that instance, the appeals council may expedite your appeal to put the two together. Possibly. Remember, this is all work in progress. Let's say you have a new condition. You're alleging that maybe, let's say you found out you had cancer on January 2nd and it's terminal. Well, that's a new condition that you can apply a new application for. So if you've got an old claim because of your back pressure, bad back and high blood pressure on your old claim, and now you've got a new claim for cancer, that's totally separate. Keep in mind, you have a tough choice. And like I said, this is still fairly new. If it's at the appeals council and there's some new and material evidence that the old judge didn't have that wasn't available. Let's say your primary doctor sent you to pain management and the pain management doctor couldn't see you until after the hearing date. That's new material evidence that you could send to the appeals council for review. So keep those things in the back of your mind. Also, if you already have a new application pending and an old application pending at the appeals council, they're not going to cank both of them. They're not going to say, oh, you got to pick one, because you're already in the system. If you're at a federal court level and you won the federal court level and they've sent it down to the appeals council level to be scheduled for a hearing, that one won't be canked. So people, I'm going to tell you right now, this new ruling is designed to make it so that Social Security can focus on that one major application that you have. It's going to be weird in the next couple of months and so forth. So I tell you this, and this is probably more so important for people who are at the hearing level and you're waiting for a decision from a judge. If you don't have a representative, make sure you talk to Social Security to get a complete understanding about the ramifications of appealing or not appealing. If you do have a representative, make sure you speak to them so they can get you up to speed. All right, there are your answers for today's questions. Again, thank you for listening to another edition. And remember,